Informal probate in Utah costs an average of $1,600 to $1,900. The court filing fee in Utah is $360 with an added $5 fee for filing various documents, so $365. Most competent Utah probate attorneys will then ask on average about $1,200 to $1,500 for their services. So the total fee with court filing fees is about $1,565 to $1,865. These costs are costs in 2017. The costs are paid from the deceased person's assets. Informal probate can take as little as 2 to 3 weeks depending on the particular judge. Sometimes, if there are various complications in contacting beneficiaries or heirs or other complications arise, informal probate can take as long as 3 to 4 months. The costs of probate litigation is a completely different matter. Once a complaint or petition is filed with a court of law, probate litigation has begun. And once probate litigation begins, it is unavoidably expensive. Most Utah probate attorneys bill their time at $200 to $350 per hour. That again is in 2017. And most probate cases require 80 to 100 hours of an attorney's time. Any attorney promising to resolve a typical probate litigation case for less than $15,000 is not being honest. In our 25 years of experience, each party in probate litigation will pay an average of $15,000 to $20,000 to fight their case. That is each party, for a total of $30,000 to $40,000 for a typical probate litigation case. A small percentage of cases cost less than $15,000, some as little as $5,000, and a small percentage of cases cost more than $20,000, much, much more. But approximately 70 to 80% of cases cost each party in the range of $15,000 to $20,000. Keep in mind that a good attorney will always be less expensive than bulldog attorneys. Bulldog-type attorneys always and unnecessarily drive up costs. A good Utah probate attorney is tough, but knows how to effectively resolve cases while efficiently keeping litigation costs as low as possible. In regard to the time involved in probate litigation, we have found that a small percentage of probate litigation cases take 3 to 5 months to resolve. That is relatively quick. Another small percentage of cases last longer than 16 months. In our 25 years of experience, most probate litigation cases last from 5 to 16 months. The length of a case depends entirely on the following: the willingness of each party to settle, the intelligence and willingness of the attorneys to control their clients and resolve the case, the experience of a judge in probate litigation, and the control a judge has over his or her court in this unique type of litigation. Finally, no one can escape the Utah procedural rules that allow both sides in the litigation process to take weeks and months to file various pleadings or conduct various acts, such as questioning witnesses. Probate litigation is a serious matter, and proactive efforts should be made to avoid it. This concludes our brief presentation on the costs of informal probate and the costs of probate litigation.